try to have an inventory, yes, Your Honor, which will demonstrate to you that indeed as at 6:30 a.m. yesterday, the accused person had lost his 2 phones. And of course he was in custody. So he could not speak to third parties. So, Your Honor, the averments in the affidavits by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer you to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono said that among other places, they went to accuse persons Italian Milimani residents. That is repeated at paragraph 4 and paragraph 5 and paragraph 6, the order. The order that they received, 1 is Rongai resident in Nairobi. 2 is a residence in a place called Kipomet.
Come again.
First is
No,
second is a place called Kipomet. Kipomet. Third is Nairobi residence in Kileleshwa. Okay. So that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly to seek to deny the accused person bail, they are saying that the motor vehicles that are said to have been vandalized were vandalized when they were searching his Italian residence. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian residence is not captured. It's not there. And therefore, Your Honor, we are appealing to you that the evidence that have been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused person's phone are genuine. And Your Honor, to cut that, I would want to refer you to the Evidence Act, Section 106, capital B.
I refer you to SOPEC. Have you read it reason?
I did.
Honest to records.
Thank you.
No, I'll try 3 minutes at once, and you stop with your time.
Be sure it is 3 minutes.
Stop there.
Yeah.
The first point, Your Honor, is just to raise a point.
Now, I expect you start with what you wanted to raise.
Yes, that's what my question is. Your Honor, Section 106, Appendix B of the Evidence Act is very clear in the manner in which electronic evidence is accused. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling reason.
Slow. Let me remind you. The applications contained in the
And in the absence of the electronic certificate, the annexures are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition to bail. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the court, not a warden of the state. Bail and bond for pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge Your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it. Thank you.
Jerry, your last soldier. Is it your last or?
Listen and then I talk about Amino.
Dr. Amino.
Thank you, Honor. I'll take only 2 minutes.
Professor, you said you were taking 2 minutes.
2.5 minutes. Your Honor, I'm very glad to appear before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in the maiden open event. You are the first that I'm hearing before, so I'm very privileged. Secondly, I'd like also to thank my former teacher, Simio. I think he taught me very well, and that's why I've been proceeding all. Now, the point that I want to make is just one or two. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean to serve a compelling interest. What is a compelling interest? I will not go into that issue because my senior counsels before me have already spoken about that. How do we look into the classification of what the state has alleged? Classification